I hope you're well.
I'm very well. It's a privilege again.
Mm. As always, thank you for speaking to us. Let's start from where I just landed. This matter of Ameyaw Ekumfi's lawyers heading to the Supreme Court over SMCD 1 and 7, SMCD 141 and 7. Now, I'm sure you're familiar with these provisions.
I'm not sure. I'm not sure, but let's see how it goes.
Yeah. According to them, and they're saying SMCD 140, Section 1 and Section 7 are the provisions that they are challenging. Section 1 of SMCD 140 stipulates that any person who intentionally dissipates public funds can face up to 10 years in prison, while intentional misuse carries a sentence not exceeding 5 years in jail. Section 7 holds directors, officers, and partners liable for offenses committed by a company or partnership unless they can prove the offense was committed by someone else or that they exercise due diligence to prevent it. Now, these are the arguments they are making, that these two provisions are inconsistent with the Constitution. Do you see any inconsistency?
Well, I must confess, I haven't seen the charge sheet in respect of this Sky Train matter. Neither have I read thoroughly the SMD 140, the sections that you referred to, particularly 7. But my understanding of the legal challenge being raised by lawyers for the accused person stems from Article 19.2c of the Constitution. The whole of Article 19, as I understand it, has to do with fair trial, and it provides for fair trial in criminal cases as well as civil and other adjudicating bodies. By the fair trial rule in 2C, 19.2c, the understanding is that the Constitution guarantees a presumption of innocence of an accused person facing trial. What it means is that the accused person ordinarily will bear no burden of his or her innocence, but rather the prosecution or the state carries that burden of establishing the guilt of the accused person beyond all reasonable doubt, except where the accused person is proved guilty or is found guilty. So my understanding of the issue of law of constitutionality being raised has to do with the language of Section 7 of SMCD 140, which appears to have shifted the burden of proof on the part of the accused person. But generally, these type of provisions are not uncommon in all common law jurisdictions. We call them statutory exceptions to the general rule of presumption of innocence. And I think there is a jurisprudence or philosophy behind it that is deeply steeped in the common law, which we have inherited from England, and that have also found expression in our statute and this very constitutional position. Now, in this case, the law creates those statutory exceptions, which are referred to as the reverse burden of proof. Now, there are certain matters that are deemed or considered to be within the peculiar knowledge of an accused person. And the law deems such matters to be unfair, to be placed as a burden on the prosecution to prove or to disprove. For example, if the law is that it is unlawful or criminal for someone to drive without a license issued by DVL, and the police have every reasonable suspicion that yours is really I'm driving without license or I'm not licensed to drive. The law shifts this burden of proving that I'm licensed to drive. Because these are matters, or this is a matter within my peculiar knowledge. All that I'll have to do is to produce that license. And once it's certified to be valid, that burden is discharged. So many of these statutory exceptions exist in our criminal statute, where rather than requiring the prosecution to produce that evidence to prove or disprove a matter in issue as regards the criminal offense charged, the accused person is deemed to be in a better position to provide evidence in proof or in proving that peculiar fact within his or her knowledge. I think that is what Section 7 has done, and it is not uncommon.
Interesting. So it's not as if in every criminal proceeding, the burden of proof is always on the prosecution. You are saying that there are some exceptions to the rule because they believe that in those cases, the accused person has more knowledge than the prosecution of the matter.
If at a particular issue, the specific fact is within the peculiar knowledge of the accused person to simply provide that evidence. However, it should not be lost on us that talking about burden of proof, we are talking about two different things. We have the evidential burden, and then we have the legal burden. The legal burden never shifts to the accused person in those circumstances, but simply the evidential burden of proof and producing that little information or evidence in proof or in disproving the allegation. However, on the totality of the case, that burden of proving the guilt, which is the legal burden, to establish all the essential ingredients or constituents of the offense, so lies on the prosecution. So I haven't seen the point of law being raised, and if my guess is right, then I think the lawyers are asking the High Court to refer this matter of the consistency or inconsistency with this statutory exception in Sections 1 and particularly 7 of SMCD 140 against Article 19. And to clarify, in that case, once the matter of reference has been made by the High Court under Article 130, Clause 2, to the Supreme Court for interpretation, then automatically the proceedings in that higher court must be stayed. That is my understanding of what the constitutional issue being raised is all about.
There's something you said, just by way of clarity. What do you mean when you say the legal burden really never shifts to, what do you call it, the accused person? That what the accused person really carries is the evidential burden. Explain that.
Okay. So, for instance, the offense or the offenses that you mentioned, that they have been charged with some counts of willful causation of financial loss. Is that what you said?
Yes.
And then also dissipation of
Public funds.
Public funds.
Yes.
Okay. So when you take those provisions, there will be specific elements of these offenses that have to be proved by the prosecution. Each of them must be proved by every means possible. Okay? That is the legal burden.
Okay.
That must be discharged.
You must prove every offense.
Yes, all the essential ingredients. So, was there a public fund? It must be shown by the Constitution that the fund in question was public fund, as defined by the Constitution or any other law. It must be shown that there was in fact a dissipation. I'm just giving an example. I'm not suggesting that I know the ingredients because I haven't seen the law. Okay? So, was there dissipation? What even constitutes a dissipation? Must be a question of law, or maybe a mixture of fact and law. And what constitutes willfulness? When can it be said that someone has willfully acted in a certain way? Okay. Is willfulness the same as intention? Or can it be equated to recklessness or negligence? These are all different levels of mental state, or what we call mens rea in criminal law. These legal issues constituting the offense as the essential element must be proved by the prosecution. But in the course of doing so, evidence will be led to establish each and every one of them. However, there is a particular piece of evidence on a matter that is deemed to be within the peculiar knowledge of the accused person to explain. And that is the only evidential burden which, in my view, is passed by the law in that exception.
Okay. In this particular case, and it involves the money spent on the SkyTrain project, the $2 million that we've all been trying to understand why that money was paid and what work was done. Now, the Section 7 that is in dispute says holds directors, officers, and partners liable for offenses committed by a company or partnership unless they can prove the offense was committed by someone else. Now,
good.
The person involved in... Okay.
I don't get it. So
okay.
The exception lies in what you just said. Unless they can prove that the offense was committed by somebody else.
Yes. Or that they exercise due diligence to prevent it.
Fantastic. So these are the statutory exceptions. Okay, so first, they say that, well, on the basis of what the prosecution has put forward, your guilt is looking obvious. Can you explain that? Well, although these allegations against you did happen, but they weren't carried out or asked done by you, by someone else. If you are able to explain this, you walk free. Or that was the other one.
Or that exercise due diligence to prevent it.
Fantastic. You should be able to explain this way that you exercise due diligence. For instance, if it needs a board approval, was the board consulted and the board approval sought? It didn't need any management approval. It didn't need any kind of procurement, clearance. It didn't need any internal controls within the institution. That ought to have been followed, and which were in fact followed. Then we would have shifted the burden to whoever failed to act or acted in a certain way. So, in my view, I think the challenge is those two matters that you raised. That is where the lawyers are trying to test. I will not sound prejudicial as these matters are still pending before court. But all I can say is that it is never uncommon in our jurisprudence of criminal cases or criminal statutes to have these statutory exceptions where an accused person is deemed to have peculiar knowledge of special or specific facts or peculiar facts that is enjoined by law to provide evidence to establish or to disprove. Otherwise, then most of our criminal statutes will be rendered unconstitutional and in effect also render criminal trials in most cases impossible. If you come to other offenses like what we call the street liability offenses, for instance, where the state doesn't need to prove any particular mental state, the fact that the act had occurred is enough to take you to have been guilty or something, and you needed an explanation. For example, if you run through a red traffic light, what must the state be required to prove beyond showing that the light was indeed red and there was no policeman or traffic warden standing there signaling you otherwise to run through it? Once you run through it, why must the state prove and establish the state of your mind with which you ran through the red light? It's enough to show that the light was red and you ran through, and there was no signal from state authorities directing traffic at the time, allowing you to do so. So the explanation must be with you to show what happened.
I see. Well, not to be the serpent that leads you into temptation, but I am guessing what the state is putting forward is a suggestion that Ameyaw Ekumfi was chairperson of the board. Perhaps we have evidence that you and some members of the board or entire board approved this money being spent. So by SMD 140 section 7, we are holding you accountable.
Well, I don't have the details of this cycling matter, but I'm only picking the bits and pieces from the media reports, right from the early days of the SkyTrain pamphlet. We were all excited to see a SkyTrain and it never happened. And now the matter is in court. For now, that is all I know. I can't say anymore.
Well, let me then conclude with you by asking you, and I'm sure, I don't know if you were listening to some of the voice clips we were playing from Parliament, the disagreement between Bernard Ametefe, who is chairperson, honorable member of Parliament for Akachi South, chairperson of the Appointments Committee, deputy speaker, and then Alexander Afenyo-Markins, who is minority leader. Alexander Afenyo-Markins seems to be claiming that we have a constitutional crisis on our hands. One, because the CJ has been suspended. Secondly, it feels that I think it dates back to Justice Sophia Benasquesa, Professor Richard Frimpong, the attempt by the former administration to nominate and get them vetted and approved to be on the Supreme Court, and how the NDC at the time pushed back, and how he feels that this particular proceedings shows the hypocrisy of the NDC back then. And also, he's also suggesting that the president was the one who sent the names to the Judicial Council, and which is against the norms, among others. I don't know if you're listening and what your thoughts are.
I just heard from the clips that you played, and nothing more than that. And I don't think that the cry of Alex Markin are justified. But these are all the usual traits of him. If there has been any one person whose conduct has sought to undermine the independence of the judiciary from Parliament, it is him. This is one individual who ran to Parliament, seek a stay of execution of a ruling on a matter before Parliament, and seek to enchant or prohibit the Honorable Speaker, head of another arm of government, to be prohibited by the court. He has succeeded in doing all that. To date, what has become part of our history is that persons who willfully cross carpet in violation of the Constitution, the men in Parliament, so Parliament was dissolved at the midnight of 6th January 2025. Those persons would have vacated Parliament and forfeited all their entitlements as end of service benefits, but were kept in Parliament in violation of the Constitution under the guise of constitutional interpretation and enforcement by the Supreme Court under the suspended Chief Justice. These actions were engineered by Alex Markin, and he is giving moral lessons to us about constitutional crisis, independence of the judiciary, and all that. Then I can only say that we don't want to take moral lessons from a prostitute. I don't have any more to say.
Thank you very much for speaking to us. David Ametefe is a private legal practitioner. Join us on the line for a quick conversation on those two issues that we raised a bit earlier on. So, two things. One has to do with Parliament's power to vet and approve Supreme Court nominees. And then the second one has to do with Professor Ameyaw Ekumfi's challenge. In fact, this is the story. And it says lawyers of Professor Ameyaw Ekumfi have filed a motion at the High Court seeking to halt his ongoing criminal trial. So what they're asking the High Court to do, they will go